Alpha OneTV. All the latest updates in now. I hire ni now. Sesen ko be like and share. Na ma onu aso ye de enye bintie already. Yenkongo tin simbia a speaker Bagbin no lawyer Kesi about different title sorry and they have to ja. Ni sama o kano a niema efa a the outgone a Chief Justice Getri Tokono any Afenyo marking. A title sorry by sharing the relationship between a year Getri Tokono any Afenyo marking. Now, Chelsea pay information could tell on Chelsea. A year Afenyo marking any Tokono. Ye capa mukromi near Fuanesa. Obe church into a cancer. Na idea or can ya a year humpane say. Afenyo marking was having a personal interest. Personal interest. In your party interest, do. Personal interest. Letting a Tokono being the Chief Justice. Because our personal interest they are there a deep personal gains a profit huge one a brano quite benzo in kunkuti a title sorry in some
to some extent I would blame Justice Xcannh because as I have said I think I've said here or somewhere that his own report is the problem. The minority leader was one of the reasons why I petitioned, or my client petitioned for the removal of the Chief Justice. There was a huge count which mentioned his name and mentioned the acts that formed the basis of our petition. What was this count? We said he had set a precedent, in fact, a record in the court by being the only party or being the only person who within 2 hours was able to get a full panel of the Supreme Court presided over by the erstwhile Chief Justice to give him orders that by the scope of the application before the court, no court of in the world of the common law jurisdiction will give him. Now, in the course of all of those proceedings and after, people who knew the two of them spoke to me and they said, don't you understand? That is his sister. The removed Chief Justice is his sister. When
sister in terms of
they come from the same place.
Okay.
1, 2. When her father died, the minority leader hosted her visitors, and people who were there called me. So in some of the, if I had attended the next proceedings, the next person against whom I was going to raise that objection was the Chief Justice. I said, you know, all of these arguments we are having back and forth, and you are literally descending into the arena of conflict, is because somebody that you are close to is the plaintiff in this particular matter. Who was the plaintiff? It is Afenyo marking. 2, there is now information coming out that there are services being rendered in the judicial service which are linked to Afenyo marking. So
services being rendered?
Yes, certain services. I mean, I don't want to give all of those details because I have it, but it shouldn't look personal between me and him that he's rendering those services and getting commercial profits from them, and huge ones. And so at this point in time, when Afenyo marking is making it look like, okay, there's a national public interest aspect of all of this nomination process and there's some dispute and all of that, it has nothing to do with a minority position. He sold it out to his colleagues to believe that, well, we all have to take a collective position against this, but it is a personal interest.
So in other words, you say he roped in the party, but the agenda is nothing to do with the party as a whole?
If you ask me, yes. And I'm saying that when we petitioned, there was every evidence to show that insofar as that aspect of our petition against Afenyo marking was concerned, there ought to have been a definite finding on it. 1, we said there was no basis for the speedy fixing of that matter for hearing. Her response, and that is documented, is that no, there was a basis. And her basis was that, look, I had already issued a directive to the effect that election matters should be expeditiously dealt with. Question, was this an election matter? No. It was about cross-carpeting.
Yeah.
So Factually, that's not correct. Legally, it's not correct. 2, she attached that her directive, and this is a lawyer and the Chief Justice. When she attached the directive was dated December 2024. This case took place in October 2024. So as at that time, there was no directive. So it was clear that this was a person who was doing a personal favor. There was no rule of law. It did not even accord, there was no practice direction according to her. Her principles on the basis of which she fixed it, the circumstances didn't exist. And she plainly lied in her response. Why was that not a basis for her removal? That the person who represents justice in this country can literally look at us, lie on the face of her own paper, only because she wants to justify a position she's taking to favor a particular individual. And that individual now wants us to believe that, oh yes, there are real and genuine reasons why we shouldn't be having a vetting. And because of who we are, we haven't checked. But look, seriously speaking, we don't see any dispute here. And so the facts that we have show that you have an interest in her being there. And so he's crying louder than every other person because he has an interest in the woman being there. If we interrogated all of the counts upon which we petitioned the president for her removal, you see that they would have sustained.
Why were those grounds left out?
Yes, I'm giving you one of the examples. That in Afenyo case, the committee ought to have found, and that's what I'm now saying, I blame Justice Poorman. If he had made those findings, he wouldn't be sitting down there saying, oh, and then even Justice Poorman did this, he's a beneficiary and all of that. Justice Poorman is too much of a legal luminary to understand that the position of Chief Justice is not his automatically. And so was even Justice Bafuboni. That upon her removal, there was no contract, no law, which said that they will be the next. So why will they be doing that only because they intend to benefit? When you sell that out to the public, you're not being honest. Because we have just seen in recent times that the most senior justices have been ignored and other people appointed. Why is it that these people who have been there and have seen themselves being ignored in favor of others would believe that removal of the Chief Justice would be to their benefit? It clearly doesn't make sense. But when they sell it out there, it goes out and resonates well with certain people because there's the sense that, oh, some people were interested, they just wanted this political and all of that. Poorman, Kulendi, all those existing justices, none of them has a guarantee. In fact, the Chief Justice doesn't have to be a justice of the Supreme Court. He can be taken from anywhere at the bar. There's no requirement that the next Chief Justice to be appointed, or even the one that was just appointed, ought to have been a member of that court, of the Supreme Court. No. In fact, they could have taken the person from the Circuit Court or the District Court and appointed the person Chief Justice. So why were they doing this to favor a government when they had no contract with the president that, well, if you remove her, I'll give it to you? And if that was the case, Poorman did it. Poorman was the chairman of the committee that removed her. And I'm saying that the removal actually took place because there were laymen who understood this thing in simple context. That how can a Chief Justice be doing all of these things? If we were left to us lawyers alone, all of these arguments that don't even add up or make sense to the ordinary man would have.
So the issue that the thing was in certain courts, ECOWAS court, and she had filed certain petitions and so the court should wait to hear from them before the appointment.
And the e-levy case, what is the final determination of the Supreme Court on it? Before it was implemented and we were paying, who was Afenyo backing in Parliament at that time? There are so many of these cases that have been pending and things have happened and people have moved on. And so pending cases
cannot affect these decisions
at all. He knows better than that. I'm saying that there have been several cases pending. I took Soyine has a case pending for close to 10 years now, involving ratification of mining leases. That case has never been called from any year up to now. And his point is that there are some mining leases which have not received parliamentary ratification, and the Supreme Court has determined that without parliamentary ratification, you don't have a mining lease. Those companies are still mining, and mining very well. Does he know that? And a case that has been thrown out already several times, we must wait, because the position of Chief Justice is a personal one for the person who thinks they are better suited for it, and for those who think they will benefit from it, that position. It's clearly everything I didn't think was right. It was not fair to the Ghanaian public at all.
You mentioned in the beginning that you have never really been a fan of the vetting process,
yes.
But this one in particular had reached an all-time low.
Absolutely.
What is the process supposed to be like?
Now, if the process is supposed to judge the competence or otherwise of a person to occupy a position, you find that there are all types of questions that do not relate to what the person is coming to do. You are talking about the Chief Justice, who mainly performs administrative duties. The reason I will side with this Chief Justice, I will have voted for him, is because he has spent a number of years on that bench, right from the lowest level to the highest level. He has seen the administrative problems.
I've been a justice of the Supreme Court since 11th of June 2008.
Can say he was a driver's mate, or he can say he was in a subordinate position and couldn't influence them. He has at least a year right now to show us signs that with all of that wealth of experience, he's been able to set in motion certain things that people can benefit from. The removed Chief Justice came with all types of policies that she alone could boast about in respect of their success. Oh, there are clear-cut rules that say, when you file a process, the next stage is this, and the next stage is this, and the next stage is this. She comes to say, look, there are new rules. This case will be fixed for hearing only after certain steps, ignoring the clear-cut, the rules made by Parliament. She had power to ignore them because she says, I'm implementing reforms. What did it result into? Simple applications for 6 months in the Court of Appeal and in the Supreme Court. You wouldn't get them heard or fixed for hearing. Oh, Adenta Court will sit morning and afternoon. For what? How many? Somebody should show me. I wrote against it, first of all. Somebody should tell me what it achieved. It only disorganized people's lives. Because you wake up in the morning and then your case is in the afternoon. In the afternoon, it's not even started. You go in the morning. The morning, which knows that it has to close by 12 or 1 in order for a new one to come. 10 o'clock, the person hasn't started. Hasn't started to deal with any case. So the process was not really geared towards new Chief Justice. People are complaining about justice delivery. People are complaining about adjournment of cases and all of that. Tell us practically what the issues have been. Tell us exactly how we can tackle these problems. Because when I started practice, judges were writing in longhand. They were very effective. Their cases moved faster than today when judges don't have to write. They say things are electronically recorded. A motion for joinder takes you 2-3 months. Something that in those days,
they were writing in fast longhand,
and I'm saying
things were moving.
Oh yes.
Wow.
I'm saying in those days, before you even got up to move a motion, the judge knew the basic principles, had read it, and the lawyer needed only to focus on specific issues that would sway the judge's mind one way or the other. On some occasions, joinder, injunction, stay of execution. These are things that judges would dispose of in those days very easily. 6 months, a lot of them, they are still sitting down there. Those are the things I expected to hear the Chief Justice respond to. Are you even aware of them? How many lawyers have you spoken to in connection with the justice delivery system, and to tell us what their frustrations are? Have you received any petitions? What are they in respect of? What do Ghanaians want to see in the justice system? He must have seen some all through these years. Let's have a practical interaction so that we can hold the Chief Justice to some of the things that he says. You know, what we are all over the place. And you are vetting somebody for the position of Attorney General, and he has to dance Agbaja.
The Agbaja dance, do you know how to dance it?
was for title, sorry, it means on some Dawson, some necessarable. Now, what me say, you know, between the about a public domain. Now, yeah, sometimes the way amount for Sikasa, as you say, they are all knowing, they are all right. Meanwhile, underground, only a hypocrite. They portray themselves as you say they love Ghana. They portray themselves as you say they respect the constitution and they want the right thing to be done to benefit every Ghanaians. Meanwhile, underground so yes I know what here. The actions are different from a Kasa. And one here, bit mobilize a lot of people. Amanite follow or no. Meanwhile, who will follow no at the end no, unya benefit biya. Now so the side now to dream say, yem fighting my Ghana fu nyina. Na yeah Ghana fu nyina na be benefit. Meanwhile, onu mum na benefit 100%. Sa nyema no and okasa Afenyo marking sa not here. Because enka nsema working or chese enka any PPMPs for binum pu enim se sa na ekoso a ebia komo mfa na adwen de Afenyo marking. Afenyo marking is there fighting as is or fighting my Ghana for nyina one. As is or fighting my no political party too. Meanwhile, title sorry person say Afenyo marking fighting or fighting team or soon or court near bomb sem to go or your press conference Ghana phone tea vetting or distracted and kusiaga a more foreign court sending near money actions away in no pay title sorry say or personal gain having a get token to be the Chief Justice and maintaining a position or personal gain. Or see the way I was seeing Mammy Tokono City no. Or my mechanizing maybe on my build something as if so a idea Afenyo marking gaining some profit. Huge one gaining through the position of a Chief Justice Mami Tokono bed ebe no na Afenyo marking benefit and so no ha so papa ya friend Afenyo marking no opia wa ba bontin a ne ka say different opia ba bontin a the actions different na one yes smarter ne kasa you sitting team do see fighting for no here obeya mo believe the okano. Meanwhile ne agenda a different agenda. Se wu nim niema e kokoso na be den so be hu insanim chichimu isa wuti na title sorry. Se title sorry person say the client one of the clients can be no the petition come president Mahama. Na petition mu no niam mo raise wo no komo boas interrogate a ka Afenyo marking mbegu asi bibre. So anytime bia okasa say oh petitions na mo de coin no crampo no yini nyina na mahwehwe mo wi mahwehwe ba akopem wi petition no crampo no mahwehwe mo wi wose ka mo yewe nyina wi ansa na mo de ruling aba. Oh, I was like I'm train my court and yen BBA and son of Macassi with diffu and with dibim. Me as in obe maintaining a seat and I say position Nikutan obe maintaining and also be front. Gaining in name 5, 10, 20 years grandpa and train. Now, or just say, Casa investigation in na Baniria, Kawapoika no betchin papa. And ebe man for crime peace and more parliament in po out him mobilize your control mo ye work out no mood nechi yen ko no no so the mood nechi yen ra no mood nechi kebe crown kasa investigation bi nyina ba wanti ha kebe mark MPs kakra o na omuta nechi no komu nyina mo ni beda ho amane hu say ye ka hypocrisy eyonwa. And those MPs na ye come wasem. Yes, you have to respect your leader, and as a leaders in parliament, whether majority leader or minority leader. But fashion with him say, and you leader no and a trumba parliament house. And you leader and a car say, okay, the person will over parliament house. No automatically over parliament house there be. Obi every different constituency in the buying. Kai who say the pardon any pin or share that parliament house or no. Without those people in your constituency, no, can any day say beba parliament house. I bet she will be a friend leader be answer. So your people in your constituency should be your priority. Momness or the motto first. So leader our parliament house on us no. And Crawford be na bar. Who knows say Crawford no more than a bar no. They are saying say vet na a far a year Chief Justice for Buffalo Bonnie no. Or more per se or more MP no sorry P. What if? Na sa MP na sorry P. For example, sa MP na sorry P. Sene bia obey dia so ne constituency for any a. Na wo constituency de omon kan sanjewa na wo di echi. Afenyo marking constituency on a demo nyina moba eye parliament. Ubia on the constituency or pushing it back parliament house. So if say one MP is rapia, you don't know the reason why I was rapia. Bia the constituency for no here no. Now so as ready na china wapi. Sometimes I was saying munyina montana say your constituency and I think from pia mo ba no or mum and some way the muti mo first. Even maybe cry no. Yes, or mum na some muti in the first. Now my entire now caso could do BH or a leader a time will come Obeko constituency and as a constituency was say or more than enter about or more to about because one serve you more or more. Afenyo marking constituency no more to mount ebedai. Sometimes I was see a drink query. So these are the exposés are airtight was sorry the brain. Wakasa ye po akansi we I fa the outgone Chief Justice in Afenyo marking. Subscribe na share manu asinye binti Akroma.